Hello, America. I'm Mark Levin, and this is Life, Liberty, and Levin Sunday. Thanks for being here. Two tremendous guests, Professor John Yoo and our friend Ben Shapiro as well. I'm not a very happy camper, ladies and gentlemen, not in the least, as a result of inactions taken by the United States Supreme Court in a 5-4 order the other day, which you're generally familiar with. And this is an order that basically told the Trump lawyers in New York, go ahead and proceed with your judicial abomination. And you have no recourse. Now, I want to discuss this at some length because I think some of the legal analysis is fantastic, but it's way off point. The issue here is not just what happened in that courtroom. What happened in that courtroom in Manhattan was a disgrace. The jury instructions, prejudicial testimony, phony laws, ignoring the immunity decision of the Supreme Court, and so forth and so on. The fact that the judge ruled that he's not going to imprison the President of the United States, that's not a victory to me. Now, let's start from the beginning. We have something called the Supremacy Clause. Why do we have that? I'll tell you why we have that. We had an Articles of Confederation, and the problem was the national government had no authority. The state governments would thumb their nose at the national government. The state governments were fighting with each other. The national government couldn't raise taxation even to have an army, even to pay its debt. And so a number of our founders got together and said, we got to change this. And long story short, we got our Constitution. One of the areas that they debated at length, was, well, whose law should control what? Because that was the heart, the core of the problem before. So they came up with, is today, Article 6, Clause 2, the Supremacy Clause. Now, what does it say? This Constitution and the laws of the United States, which shall be made and pursuant thereof, and all treaties made or which may be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Wow, that's a big deal. There was a lot of fighting over that. There were 3 iterations over this language. There was fighting at the ratification conventions, but they said it must be done if we're going to have a republic, if we're going to have a functioning country. What took place in New York was a direct attack on the Supremacy Clause in a functioning country and the purpose for the Constitution in the first place. Now, I can get into the 5th Amendment. We did that last week. The 6th Amendment. I can get into the 8th Amendment. I can get into the 14th Amendment, which applies the 5th Amendment and other amendments to the states. We can get into all that. I can wring my hands about what took place in that courtroom, and we can go all over it all over again, a long list of outrageous decisions, outrageous acts, phony laws, and on and on and on. That gets us exactly nowhere. And so President Trump's lawyers, wisely, they go to the Supreme Court, although at the 11th hour, and they say, look, we want a stay. We want you to stay this Merchan, his sentencing, before he puts that, that scarlet letter on President Trump's forehead about convicted felon. So we have an opportunity to do our appellate work in the New York appellate system. And in addition, they, in their brief, they included several arguments that I've made here. And what did the Supreme Court do? This is all they did. It's no opinion, it's an order. And here's the order from the Supreme Court. The application for stay presented to Justice Sotomayor, and by her referred to the court, is denied for, among other reasons, the following reasons. First, the alleged evidentiary violations at President-elect Trump's state court trial can be addressed in the ordinary course on appeal with the New York courts. Second, the burden that sentencing will impose on the president-elect's responsibilities is relatively insubstantial in light of the trial court's stated intent to impose a sentence of unconditional discharge after a brief virtual hearing. 4 justices, the originalists, Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh, would grant the application. They said, wait a minute, we need to hear this case. 5 said no, including 2 appointed by Republicans, 1 appointed by Donald Trump, the Chief Justice Roberts and an Associate Justice Barrett, who's obviously flipping, and she's flipping more and more and more. And Justice Roberts, who I've talked about before on radio and TV, he's very much influenced by the legal media, by the New York Times. He's very thin-skinned. and he has, in many respects, lost his way, in my humble opinion. If we had had a Chief Justice, William Rehnquist, and if we had had an Associate Justice, Antonin Scalia, with, in addition to these four outstanding justices, it would have been a 6-3 decision, and they would have taken up the case. They would have addressed this. Why? Why not just let this play out in New York? Number one, if I'd been filing on behalf of the president, this is not an attack. This is just a statement. I would have filed, and the headline would have been, Merchan and the New York courts have no jurisdiction. Not stay, so I can go through the New York appellate court process. It would have been the marquee point, probably the only point. And then I would have backed it up with support. Because that's the bottom line. This judge, that prosecutor, the New York appellate court system has no jurisdiction. So why play in the jurisdiction while you're trying to tell the Supreme Court they have no jurisdiction? That's my view. Now, why is this important and why is that true? I read you the supremacy clause, did I not? Well, what are we talking about here? Without federal campaign law, even though they played, hide and seek with it, it was the underlying law that was used to apply the hook to everything else to bring it in. This DA and this judge had no authority whatsoever over federal campaign finance law. They knew it, which is why they would never mention it until the very end. They knew it, which is why they would not allow the former chairman of the FCC, Bradley Smith, that is the judge, to testify about federal campaign law. They didn't want that front and center. Why? Because they know what I know. They would have lost jurisdiction. Jurisdiction, that's number one. But I want to focus on the court and these two justices, Roberts and Barrett. What is the job of the Supreme Court? I'm not talking about conflict of state law. What is the ultimate job of the United States Supreme Court? To uphold the Constitution of the United States. That's their job. That's the bottom line. Two of the Republican-appointed justices decided to take a walk. I don't know if they're cowards. I don't know what their position is ultimately. It's not stated in the order. Four justices knew we better take this up. Why? Because this is a judicial scandal. It's an abomination. The idea that the Supreme Court allowed the continuation of a judicial scandal, a judicial abomination, to allow it to play out in New York creates a monumentally damaging precedent. Let me give you an example. Stick with me. Let's say there's an appellate court in New York that has its wits. And they say, wait a minute, we don't have jurisdiction over this. We're going to reverse and throw out the case of the lower court in New York. That would be a great outcome for President Trump. I'm all for it. That would be great. But it would only apply to New York. It doesn't apply to any other state. So let's say we have an Alvin Bragg in L.A. We'll call him Ernie Grabotsky. And let's say we have an elected state judge or appointed state judge in L.A. We'll call him Merchan. And they pull the same stunt. Well, they can do it. They can interfere with a federal election. They can make decisions about federal campaign law. They can make all these abuses of the federal Constitution, of the Bill of Rights, because New York can't stop them, and the Supreme Court took a pass. What do you think about that? There are thousands of DA offices, county prosecutors, state attorneys general. They look at this preposterous order, this silly order, where the court didn't have the guts to do what this court needed to do. What this court needed to do was to put an end to this and to say, wait a minute, there's no jurisdiction. We can't have a local DA in the middle of a federal presidential election, and we can't have a local judge in the middle of a federal presidential election, number one, to make rulings like this, and then number two, 10 days before the inauguration to decide that he's going to impose a sentence, whatever the sentence is. The idea that the sentence is unconditional discharge and therefore they get a pass. Still, the court, by not acting, is given its imprimatur to this process, to the seizing of federal jurisdiction by a local prosecutor and a state judge. This is a scandal now. That's what it is. It's a judicial scandal because two Republican-appointed justices threw in with the 3 radical left-wing Democrat-appointed justices and did not vote with the 4 constitutional originalists to say, no. We got to straighten this out. We can't allow this abomination, this process to continue in the New York courts. We're giving it support. This is a federal matter. We, the Supreme Court, we're the only court that can ultimately straighten this out. This is our duty. This is our responsibility. But they said no. So right now, there's nothing to stop a local DA from manufacturing another case against another presidential candidate in the middle of an election. There's nothing to stop a state judge from doing the kinds of things that Merchan did, outrageous things that he did. And on top of that, this document here, the Department of Justice, half a century, both parties have taken the position, we need to avoid all this, like the plague, at the federal level. So we're not going to allow the prosecution, the indictment and prosecution of a sitting president. Now, the criminal justice process doesn't end at the trial court level. There's an appellate level. So what the Supreme Court did is it allowed that to go on. That is the criminal process, the appellate court process, while Donald Trump is president. They rejected the federal Department of Justice position. In fact, everything Merchan and Bragg did violates this memo, the position of the Department of Justice for half a century, which is why there's not a single federal prosecutor who would do what's being done now, which is why they had to drop their cases. Except the case in New York goes on. And it goes on. Now, this is a big deal, this jurisdictional issue. It is a big deal because they have not resolved the issue. Let me go further. Why these 2 justices were absolute cowards and outrageous in what they did, and why what they did was abandon their responsibilities. In the Bush v. Gore decision, the court stepped in without any statutory authority. Basically, there was an emergency appeal filed, just like an emergency appeal was filed by President Trump's lawyer. Call it whatever you want. It's a common law process at that point because it's not a statutory appeal or a statutorily sanctioned appeal. You could call it what I said the other day. You can call it a kumquat. Call it whatever you want. So it's an emergency appeal. This court, these 6 Republicans, 4 did, 2 did not, should have said, thank God, they have finally sent us a document. They have finally sent us this, and now we can act and protect the federal judiciary. Now we can act, uphold the Constitution, the Supremacy Clause. Now we can act and make it abundantly clear to every DA in the country, every Attorney General in the country, every state judge in the country, this will not stand. You cannot do this in a presidential election. You cannot do it to a presidential candidate. You don't get to interpret federal law once you've revealed what federal law you're talking about. You don't get to usurp the authority of the federal courts and this court, the Supreme Court. That's what they should have said. Wow, now we have an opportunity. The president's lawyers have given us this opportunity. Under Bush versus Gore, Ted Olson brings the case. And what were the questions? Did the Florida Supreme Court, the Supreme Court of Florida, violate Article 2, Section 1, Clause 2 of the U.S. Constitution by making new election law? That is, rather than the state legislature. The counting was still going on. The court was still adjudicating. The counting was still going on. The Supreme Court said, the process is the problem. We're stepping in now to stop the process. We can't have a state court, even a state Supreme Court, interfere with a federal presidential election in the Electoral College process by changing the counting system after the fact. It violates the Equal Protection Clause of the Fifth Amendment as applied to the states under the 14th Amendment. They stepped in, they stopped the process, which was becoming a scandal, an abomination, in a federal election. They didn't duck it. Rehnquist, the Chief Justice, Scalia, the Associate Justice, they didn't say, let the system play out, because the system, the process is the damage. The process is the damage. The usurpation of the jurisdiction is the damage. Now, here's the other thing. Depending on what the New York appellate courts do, Donald Trump may have to go back to the Supreme Court, assuming the New York appellate system is as corrupt as the New York trial level system. And if they go back to the Supreme Court, let me suggest to you at that point, Roberts and Barrett may in fact take the case. Who knows anymore? May in fact take the case and vote with the other 4. And so now you'll have 6 constitutionalists, not activists, constitutionalists taking up the case. What are they going to say? Oh, that whole process is unconstitutional because you didn't have jurisdiction? Well, what else are they going to say? That's the primary basis. There's other things they can say, but that's the core of it. You didn't have jurisdiction. What you were doing was without authority. You didn't have the power to do it. And so the question is asked, well, why didn't you do this in the first place? Why do you put the country through this, put the President of the United States, he will be president at the time, through this? And how are they going to justify the fact that they didn't act the first time around? It gets much more complicated, doesn't it? So the bottom line, this isn't about interlocutory appeals. This isn't about the New York appellate system. This isn't about any of that. This is about a majority of the Supreme Court refusing to uphold the federal Constitution in the face of an assault by a state, by New York. And every other blue state and every other hack prosecutor in some big city with a hack judge in some big city, as of today, has the ability to do what was done to Donald Trump in Manhattan. Because the Supreme Court wouldn't fix this. On behalf of the Supreme Court, the federal judiciary, the framers of the Constitution, and the Supremacy Clause. What's the point of having a Supremacy Clause if something like this can take place? The fact is, there is no point. Department of Justice rules have been trashed. Half a century. The reason for the Department of Justice rules have been trashed. And now let's go back to this phrase, unconditional discharge. Well, what's the problem, Mark? He didn't sentence Donald Trump to prison. No ankle bracelet, none of that stuff. Now, why did he do that? Why did Merchan do that? Why did Merchan say, you know, the sentence basically is, you're guilty, but I'm not going to punish you. Because if he had sentenced Donald Trump or done one of the other things that I just mentioned, then the Supreme Court would have to take it up because it would interfere with the office of the presidency. They would have to take it up. So this guy's conniving and he says, let me just put the scarlet letter on Trump, not give him any other penalty, and then I skate. And then he's stuck in New York. What about the Supreme Court? Those justices who refused to take the case bought into Merchan's ploy. They even cited in the order. Sentence of an unconditional discharge after a brief virtual hearing. What's the big deal? That doesn't interfere with the office of the president. No, it gives sanction to, and the court's imprimatur to, an unconstitutional stealing of a federal case that didn't even exist by a state court. That's what they did. And unless they eventually fix it, that's going to stand. That's the bottom line. That's what's going on here. Well, time will tell.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.